The Honourable Phil Goff.
Mr Speaker, the Labor Party supports this bill. As is quite common before the Law and Order Committee, that where we have legislation that is evidence-driven and that is designed to increase the security of the community, all sides of the House can work together on that legislation, both to support it and to improve it, as the Minister has acknowledged in his speech. And I think that we have improved that legislation. Is the legislation necessary? Yes, I think it's common sense, Mr Speaker, that if the Corrections Department and the police can require offenders and those on bail to abstain from the use of alcohol or drugs, then you have to have a law that can ensure compliance with the conditions that might be imposed by the court or might be imposed by the parole board. And it's kind of a nonsense to actually have, you must abstain from alcohol and drugs and then not have a mechanism to ensure that the person that those orders are placed upon are actually complying with it. So it was a matter of common sense that we should support this. I think it's well known to the public and certainly to members of the House that alcohol and drugs is a major factor, a major driver in criminal offending. I think at the point of arrest, nearly half, 48% of those arrested are affected at that time by drugs and alcohol. And when you look at the people that are on home detention and community supervision, that proportion, a half of those at the time of arrest becomes 2/3 of those given those sentences are affected by drug or alcohol abuse or addiction. So drug and alcohol is an important driver, and if we want to stop recidivism, we want to stop offending while people are on bail or on community sentences, then enforcing this provision is absolutely necessary. I think the corrections system has an absolute responsibility to minimise the risk to the community. When you look at the number of people that conditions are imposed on, there's an awful lot of them. Some 5,000 on community sentences have conditions not to use alcohol or drugs, and 15,000 on bail each year have that same condition. Now, if we were going to apply testing to all of those, we'd be talking about tens of millions of dollars, and that's not going to be very practicable. So what this bill does, sensibly, I think, is to target those that are most at risk. The whole Australian experience in this area is that when you target those most at risk, you have the greatest impact. The American experience is that where a person is on a sentence and they think there's a high chance of being detected if they breach compliance with those conditions, then the rate of reoffending goes down quite significantly, and we all hope that that will happen with this bill. Mr Speaker, most of the submissions on this bill were from organisations that weren't opposed to having compliance. Pretty hard to be opposed to requiring compliance. They just wanted to make sure that the testing was reasonable and did not constitute harassment. And I think that we have this pretty well covered. We didn't pick up many of the specific recommendations of the submitters, but we very strongly supported the principles that are set out for the Chief Executive Officer of the Department of Corrections and the Commissioner of Police when they make the rules on testing methods and procedures. And those principles are that the testing shouldn't be more than reasonably necessary, point one. Secondly, that those tested should be afforded reasonable privacy and dignity. And thirdly, testing should be no more intrusive than necessary. If those principles are followed, then I think the way in which this compliance is enforced will make sense and will be widely supported.
Sorry to interrupt the honourable member. The time has come for me to leave the chair. Members, this debate is interrupted and set down for resumption next sitting day. And the House stands adjourned until 2 p.m. tomorrow. Good evening.